Welcome everyone, and thank you for joining us for our CII webinar with Flaxman Partners. I'm Tim Groves, Professional Communities and Engagement Manager at the CII, and it's my pleasure today to welcome you all to the session, which is going to be focusing on insurable interest. Now, insurable interest is a core principle that sits at the heart of every insurance contract, yet it is one we don't always stop to examine in any detail. On the surface, it often feels obvious, but as we'll see, there are a number of traps and grey areas that can catch people out. I'm delighted to be joined by Roger Flaxman and Michael Wilson from Flaxman Partners, who'll be bringing this topic to life for us. They'll challenge some of our assumptions, explore where things can go wrong, and share practical examples that highlight the complexities that we all need to be aware of. There'll be time for questions at the end, as always, so please feel free to use the question and answer box that you can see on your screen, and we'll work through these once the webinar is complete. So, without further ado, I'm going to hand over to Roger and Michael.
Good morning, and once again, welcome to the Flaxman and Wilson Hour. I'm Roger Flaxman, and with me as always is the venerable Michael Wilson, who this morning is occupying the vaulted towers of Bieber in London. Our last webinar attracted an audience of over 1,000 people, and we're told that even more are attending today, so that's terrific, isn't it? It would require a very large venue to accommodate that number of people in person. So thanks are due to the inventors of the video conference, because without that, we couldn't do it. As most of you will know, if you're regulars, Mike and I spend our days reviewing and resolving disputed and complex claims. We do this either in the context of advocacy for policyholders, or as experts to the courts. So we see insurance from a very different angle. We see it largely when things have gone wrong. Obviously, we know very well that the number of things that go wrong are considerably lower than the number of things that go right in insurance. But when they do go wrong, they can be pretty serious for the policyholder mainly. Now, it's in this context that we become directly involved in the nitty-gritty, if you like, of the policy wordings and coverage points. And it really requires some careful thought and analysis to come to a solution which is fair and reasonable. And that's really our principle. We're not lawyers. We're looking at this on the basis that we understand insurance, we understand the purpose of insurance, and what's a fair and reasonable outcome when there's a disagreement about policy coverage. And that has to be judged to a certain extent by the reasonable expectations of the policyholder. Because after all, we ask the policyholder to read the policy and understand it. And if they think they do, then they're entitled to believe that what they've understood is more or less right. And sometimes it is, and sometimes it isn't. But clients are very much, their expectation is often based on ignorance because they just wouldn't know how insurance is going to work in practice. Why would they know? So they're looking for a fair outcome, and we have to balance that obviously with recognizing that the insurer also must have their rights and remedies as long as they're practiced with fairness and good reason, and they should be upheld. So it's no means unusual for us to have to tell a policyholder that their claim is in fact unreasonable. And we will always say that if we think that actually, no, the insurers are right, we'll say so. And we'll give them a reason why, because that frankly is the most important thing, is to be able to explain why it's not there. And it's in a case in point with that, in the last 2 or 3 years, we've seen more cases concerning insurable interest than we've seen in the last 20 years. I've no idea why, but they just seem to have come like London buses in 3s and 4s. So we thought that as we've learned quite a lot in real time about the difficulties that can arise when usually an insurer or their lawyer or loss adjuster, they point out I don't think the insured here has an insurable interest in this claim, then we thought we'd look at it and come up and give you some examples of things that you may otherwise not think of. Insurable interest really comes under the broad heading of legal considerations. And as we all know, insurance practitioners are not lawyers and usually pretty careful not to give legal advice. However, as the CII examination handbook on insurance law devotes 8 pages to the subject, it's reasonable for a policyholder to expect an insurance practitioner to know something about it and how it works in practice. And in fact, I have been asked once in court when I was in the witness box, would you expect an insurance broker to understand so-and-so? And I said, yes, I think they would. And I was asked, well, is it in the examination syllabus? And actually, I just said, I don't know, because I haven't looked it up, but I can't imagine it wouldn't be. And in fact, that's become a question which I'm often asked now by lawyers. Would an ordinary insurance broker or consultant or insurer, would they be reasonably expected to know about this if it is in the insurance syllabus? And the answer has to be yes, really, doesn't it? So it's a point that you might want to take away and think about. So, as I said, in the last 3 years, we've experienced several disputed claims on insurable interest. And in each case, we've found that it was simply a case of the policyholder not recognizing the existence of insurable interest. It wouldn't have occurred to them until it arose in their claim. And in each case, we found that neither the insurer nor the broker had paid any attention to it. It just didn't come up on the agenda of questions or answers or proposal forms or anything. But what I can say that we've never found an example of dishonesty or if you like, the gambling or fraud or anything like that. It's always just been a matter of it wasn't considered at the time. So today we're giving you a couple of examples of how insurable interest was absent at the time of a claim, and then you can have the opportunity to explore other possibilities with us in the questions and answers at the end. So with that, Michael, would you like to take it away?
Thank you for that introduction, Roger. Let me just quickly go through the learning objectives for today. To review the basic principle of insurable interest, to understand the difference between the insured and having an interest noted on the policy, to appreciate that insurable interest often goes beyond simple ownership, to address the complications arising when insuring property of multiple occupation or ownership, and to learn about some of the complications that can arise at the claim stage. Now, when I was at school, my least popular subject was history, but we do need to look very briefly at the history of insurable interest. And I'm sure you can all tell me all about the Marine Insurance Act of 1745. But basically, this was the legislation that outlawed an insurance policy which was, in effect, a gamble or a wager. Apparently, it wasn't unknown for people to insure the lives of people that they weren't really connected with, but they felt that it was a good gamble. Perhaps they didn't like the look of them, or perhaps they arranged for there to be an accident or something. So it was generally considered that life insurance shouldn't represent a gamble. And then these built up a little bit further in the 1774 Gambling Act. I don't know whether many delegates today will be working on the life side of the business rather than the general side, but insurable interest for life insurance policies does operate in its own way. And this was established in this case here of Dolby versus the India and London Life Assurance Company. It was an old decision, but it was this that established that with a life insurance, the insurable interest need only exist at the time of inception of the insurance. So that if the insurable interest is established at that time, typically it might be a husband and wife insuring each other on a joint policy. Then they either separate or divorce. Actually, there's no reason why that policy shouldn't continue. And in the event of the death of either husband or wife, even though they might be divorced, the policy will still pay out. But if you are involved on the life insurance side of things, and you're interested in the subject, do get in touch with us, because I believe there are some practical issues these days, particularly if insurance is effected by one person on the life of another, where there's no actual legal connection. So it might be a cohabiting couple, and there are some questions arise as to how you establish the insurable interest in cases like that. But we needn't dwell on that just now. So generally, the principles for general insurance stem from the Marine Insurance Act of 1906. And basically this establishes the principle that you have an insurable interest if you stand to be prejudiced by the loss of the property being insured. This relates specifically to property. We can touch on liability insurance later, but it doesn't necessarily state that you have to be the owner of the property. You just need to be potentially prejudiced by its loss or damage. You can tell by the language here it's all to do with cargo, but the principles of this act apply throughout general insurance. So what are the insurable interest principles? So for a property insurance to be valid, an insurable interest should exist at the time of inception and also at the time of a claim. Now that's what normally happens. I believe there are occasions when an insurable interest might not exist at inception, but it's probably more important that it applies at the point of claim. But normally, the issue of insurable interest is discussed and considered at the outset, and that insurable interest must still exist at the time of any claim. So obviously, it will apply in cases of absolute ownership. It might be a limited ownership of some kind. It could be under a lease, could be a trusteeship. It could be the fact that you're in possession of something, and that being in possession of something, either a property or some object, that if you're acting as bailee, in other words, if you're responsible for the safety of that property, then you have an insurable interest. And sometimes insurable interest could be established by contract. So as you can see, the principle goes way beyond, if you're insuring a property, it goes way beyond, for instance, whether your name is on the deeds of the property. It's not that binary, and these headings here can give you a clue as to how insurable interest can operate in different ways. So let's have a look at an example, because this helps to bring it to life. So this was a real case that we looked at. Mr. and Mrs. Jones owned a second home situated very close to their main residence. They effected a buildings and contents policy for their second home, and the policy was issued in their joint names. So far, so good. However, the insured were a little bit worried about the political landscape, and they were very concerned that the politicians were going to make the inheritance tax laws more onerous. And so they took the decision to transfer the ownership of this second property over to their two sons. Unfortunately, they didn't inform anybody, and they certainly didn't tell their broker that they'd done this. And I would have some concerns as to whether that would actually work anyway, but we're not inheritance tax experts, so it's not for us to comment on that. But the fact is that the property was transferred over to the two sons. Inevitably, there was a fire claim, and the insurer, quite reasonably, was checking on the ownership and the whose name was on the deeds of the property, and they found out that the insured was no longer on the deeds of the property, and so they said, well, there's no insurable interest here, is there? So we will come on to look at this in a little bit more detail, but fundamentally, we were able to establish that Mr. and Mrs. Jones had really done this for the protection of their estate. They still paid the bills. They still paid the council tax, the utility bills. They were doing some renovations to the property, and they were responsible for all the costs of those renovations. And so, taking all those factors into account, and one or two others, it was established beyond doubt that the original insured did actually have an insurable interest, and the claim was paid. So that had a happy outcome, but it could have been very different depending on the circumstances. We'll come back to this example because there are some lessons to be learned from it. Let's look at the second example. Could you bring us through this one, Roger?
Yep, absolutely. This was a case of a family who were in the restaurant business, and they owned quite a few restaurants. But in fact, they operated 7. 4 of these were in leased premises. The others were owned by Mr. and Mrs. P. Now, the restaurant business, as you know, went through a bit of a rough time during lockdown, and that's when this event occurred. But prior to the lockdown, I think 2016, the company's accountant had advised Mr. and Mrs. P to incorporate the entire group of restaurants. Up until then, they were all trading as independent entities. They were all insured under one policy as independent entities, and the insured was known as Mr. and Mrs. P. Now, because of the lockdown, they had to put 4 of the restaurants into insolvent liquidation, and the liquidators cancelled the insurance policies. Now, I'm not going to go into why, because there are questions as to whether they should have done it, but they did. And there was no insurance on these restaurants. And would you believe it, soon after that, they had a fire. And there was no insurance. Now, the point is that Mr. and Mrs. P owned those restaurants, or some of those restaurants personally. In other words, they owned the property that 3 of them were in that weren't in the leased restaurants. But there was nothing in the policy to say so. And had there been a clause in the policy, either naming them as insureds with the company or as noting their interest, then the liquidator would have been on notice not to cancel them without telling the party that has the beneficial interest in the loss. Now, that's a bit complicated, and I don't mind going through it again with you later, but the fundamental thing was that they incorporated the company, and the assumption was that the company owned all the property, and it didn't. Mr. and Mrs. P owned some of the property outside the company. So once the company's insurance policy was cancelled, there was no insurance for Mr. and Mrs. P. So that's a second example. Now, these 2 examples are typical of the kind of thing that happens. Insurable interest usually arises in unusual circumstances. The fundamental principle of insurable interest is, does a person stand to suffer a pecuniary loss if such and such property is lost or damaged? That's the main test. And you don't have to be the person that lives in it or owns the company that has it. You don't have to be in order to have a financial interest in it. Quite a lot of people, in fact, certainly in commercial business, they will run a business, but they own the property and they put it in the pension fund, in which case the pension fund has a financial insurable interest in the property. And the point about us presenting this as a webinar is that on the basis that we've now had several claims where insurable interest has been pointed out by the loss adjuster at the time of the loss, to the complete surprise of the insured, it just seemed to us that it would be a good idea to raise it, to raise the interest and say, now, here's something that maybe ought to go into every demands and needs assessment from a broker. And actually, insurers should also point out, on their website or somewhere, look, don't forget the people that may have an insurable interest in your business or your property, perhaps as a bank, as a lender or as a pension fund or any other party, somebody who has got a lien, perhaps.
Roger, should we have a look at some of the lessons learned? Because we've got some comments on the next couple of slides, which might be helpful. Because looking at the first example, there's nothing that the broker could do because he was totally unaware that his client was contemplating switching the ownership of the property, and had the broker been notified, he could have listened to who is responsible for what, whose names are on the deeds, and he could either have transferred the insurance over to the two sons or added the two sons to the policy, depending on the circumstances. But I think another lesson to be learned is that most people consider, if they own a property, they consider that to be their most valuable asset. And the weekend money pages are full of articles about how to mitigate inheritance tax. So it's not an unusual thing for somebody to take their home and do something with the ownership to minimize their inheritance tax. I was reading an article at the weekend, and this article was saying, don't just transfer the property over to your down to the next generation. You really ought to put it into trust. But then again, you see, if you've put your property into trust, that's really something that you should notify your insurers.
Yes,
I mean, it may well be that it's unnecessary. It might be unnecessary if it could be shown that the original insured still has an insurable interest because they're still maintaining the property and still responsible for its safe upkeep. But why take the risk? So I think with this being such a prevalent issue, it's the sort of thing that perhaps ought to come up in conversation between broker and client, just to double check who owns your property and are there any trusts involved. Wouldn't be a daft question at the stage at which you're taking on a new client.
And it would also be very sensible to say to a policyholder, whether they're a consumer or a business, look, are there any other people that have got an interest in your business if your business is lost? And if you're not sure, ask your solicitor, because nearly every case we deal with or have dealt with recently, there's been a solicitor in the background somewhere. And I have to say, most solicitors don't think about this. They're surprised. They understand about the law and they understand about trusts and all the things that go on in leases, but very rarely, apparently, do they give any advice as to, by the way, you need to tell your insurer. It just doesn't come up in conversation, and we think it should, because it's obviously on the radar of the industry once again. So, Michael, carry on, please.
The lessons learned on the second example of the restaurants, I think we've probably covered this pretty well. But there's a hypothetical situation here that I think we ought to consider. That if there hadn't been a liquidation, so therefore the policies would have remained in force. But the only named insured was the limited company that ran the business, and
Yeah.
Mr. and Mrs. P were not mentioned. So the policies are still in force. There hasn't been a liquidation, but there's a fire.
Hmm.
Would you expect, Roger, that the insurers would still indemnify the owners of the property, who are Mr. and Mrs. P, even though their name doesn't appear on the policy? Would you say that the insurer would be entitled to say, well, Mr. and Mrs. P own the property, they're not on the policy. Yes, there's been a fire, but we don't recognise these people, they're not on the policy, so therefore there's no claims payment. What would you make of that?
This was, you won't be surprised, this was quite a heavy piece of litigation at the time. And you won't be surprised that that question was rigorously examined. And the lawyers did say that my client, i.e. the insurer, would not have been required to pay that claim. And they wouldn't have paid it because they weren't named. Now, the other side of the story here, which is, really what we're paid to look at, is the insured had been with the same insurer for 11 years. So there was quite a lot of continuity. And all of the property that was used by all of the restaurants was insured by the same insurer for 11 years. But it was all in the name originally of Mr. and Mrs. P. And then latterly, the insurance was in the name of the company, and Mr. and Mrs. P were not mentioned. Now, our view was that it would have been unnecessary for the insurer to refuse to pay the claim because they'd had the premium. They knew exactly what the risk is. There was nothing about the risk which should have said, oh, if we'd known that Mr. and Mrs. P owned the property personally and not the company, we wouldn't have insured it. So the answer is, technically, the law said the insurer doesn't have to pay. But we said, well, we can't imagine that they wouldn't have paid. But because the policy wasn't there, the question was raised, well, the policy wasn't there, in which case there was no policy to pay out on the claim at all. Yeah. And that was the main reason why, on that occasion, Mr. and Mrs. P sued the broker and won. So this is why this is so important. These terribly small, almost infinitesimal errors of administration, if you like, can lead to
Roger,
some horrendous consequences.
that's a very important point for the broker, isn't it? Because I can well imagine a broker taking instructions from the director of a limited company.
Yeah.
And says, I've got a number of restaurants. I'd like you to insure them, please, and buildings and contents.
Yeah.
Are you suggesting that the broker should inquire just a little bit further and say, well, you're the director of company ABC Limited. Are the properties actually owned by ABC Limited, or are any of the assets owned by anybody else, as you were saying before, either a pension scheme
I
or
mean, my answer
one of the directors in their own name?
Indisputably, I think it's a question that needs to be asked. I can give you another example because there's another case which is slightly aligned to this. This concerned two shops which were on the ground floor under a block of flats. There were four levels of flats, and on the ground floor there were two shops. Now, the situation there was that the ownership of the block, the entire block, was owned by a landlord, and the owner of the shops was a director and shareholder in the landlord company, but didn't run the property. But there was a connection there, and therefore, and I can't go into all the details because we haven't got time, but there was a serious loss, and the loss adjuster and lawyer between them identified that the interests of the parties were not properly reflected in the policy. And there was a third addition, which was on the residential side. There was, I've just forgotten what the expression is now, the landlord, oh my word, I've forgotten what it's called now. It wasn't a managing agent, right to manage company. It was a right to manage company had actually affected the insurances, and they hadn't taken into consideration the interests concerning rent and various other things of the other parties in the block who weren't party to the residential section. Now, the point about this was a really big claim, and it went on for 4 years with the insurer saying, we haven't got to pay this because you can't prove the insurable interests. Eventually it was paid because the insurable interests were sufficiently clearly demonstrable that it would have been difficult for them to want to go to court and argue it. But it was a big argument. And again, the broker said, well, the client didn't tell me. And the client said, well, you didn't ask. And that's why I think it's important that we now dust off the 8 pages of the CII textbook about insurable interest and start considering whether we can put some further questions or some kind of guidance in if we're doing this stuff online to warn people that you've got to think about these other interests, particularly if you've got mixed use in a property, or if you've got, for example, family type businesses where the family might have put their interest into a pension fund or into a trust for the children. There are all kinds of variations on the theme, but you don't want to find these things out when you've got the claim.
Roger, as you mentioned before, I'm currently sitting in the offices of BIBA, and I know that you've written some notes for BIBA members, specifically on the issue of right to manage companies.
Yes, that's one of the biggest.
And it would be well worth, whether you're a broker or working at an insurer, it would be well worth going onto the BIBA website and having a look at the guidance there, because there can be some uncertainty as to which names go on the policy, basically.
Yes,
and of course, that does strike at the heart of insurable interests. So,
and again, I will say from experience, we're finding that a lot of solicitors, it's not on their radar either until something goes wrong. So you've got to spend a bit of time.
Just very briefly, going back to example 1, where Mr. and Mrs. Jones has switched the insurance over. I think we've touched on the fact that whether you're a broker or whether you're an insurer, if you're insuring a business that's going to be a little bit more complicated, then maybe we need to ask more questions. But household insurance tends to be a fairly straightforward sales process. Name, address, postcode. It's probably not normal practice to search around the issue of whether or not there's a trust involved or whether other people have an interest in the property. And I think maybe it's just something we need to wake up to. Because in the case of example 1, we were able to find a solution, but there won't always be such an easy solution. And
I think
the new business process perhaps needs to be a little bit more detailed.
I would say also that it depends on the kind of insured. Any high net worth insured is likely to have some kind of financial advisor, and take care of how they can dispose of property. They will be conscious of things like inheritance tax, and I'm just thinking of a case that there were 2 estranged parents with 5 children between them, and there was an awful lot of money when one of them died going to other parties, and there were disputes about who were the beneficiaries. Now, it's all to do with the law as to who the beneficiaries were, but the insurers got involved and said, well, until you sorted out that, we're not paying any loss. So the point I'm making is this, that when you're dealing with possibly high net worth people, or the other ones are the farming community, anybody that's involved with owning farms or property or anything like that, they often have more complicated affairs than Mr. and Mrs. Jones in Acacia Avenue, with an ordinary sort of 3-bedroom semi. It's probably not a big risk there most of the time, but we can't be sure nowadays. And I think that's the point we're making, is that you'll never know about people's complicated affairs. And whether there's a way that the industry, the insurance industry, you could, for example, simply say, we will indemnify the insured and any party with a provable beneficial interest at the time of the loss. Now, and there's somebody going to say to me, don't be silly, you can't do that. But actually, it's probably not such a stupid thing to do. Just make it clear that if there is a beneficial, if there is an insurable interest that ought to have been considered, then it wouldn't be unreasonably refused. So that's just another way of looking at it, coming up with solutions.
Let's just consider this issue of we're often asked to note the interest of somebody on a policy. Could you comment on that? Because I think you're likely to say it's not the same thing as being the insured.
I am, because again, I've along with one or two other people that in the insurance industry that do expert work, we've been asked this several times. What's the difference between being an insured and noting the interest of a party in a policy? The answer, the noting of interest does not make that person an insured party under the contract. What it does, it alerts the insurer and anybody dealing with the insurance at the time of a claim, or if it was lapsed or cancelled, it puts the insurer or the other party on notice that somebody else needs to be told that this is what's happening. In other words, notify them the policy is lapsed or being cancelled, and you need to know, or a claim has been made and beneficiaries are going to be paid out. And if you've got an interest, now is the time to say so. That's what noting of the interest means. It doesn't make them an insured party. And that's case law. I mean, that's there. I know it's very common for people to say, oh, yes, well, we'll just note your interest in the policy. If you find yourself saying that to a policyholder, actually, you should go further and say, let's find out exactly what the interest is, because you might need to be an insured.
It's quite interesting. There was a fashion at one time that if you had a mortgage, that the bank or the building society would actually ask to be a co-insured. But I don't think that happens quite so much these days.
I don't know. I haven't seen it myself, but I'm sure there's plenty of people out there that can tell us. But it used to be very common, certainly when we were young. Yeah, it did. Yeah, but I don't know if it is that. Yeah. Anyway,
so,
Michael,
Roger,
I think we're close to, yes, carry on.
So, well, it's back to you, really, Roger. I think just to sort of summarise that, we would normally expect a certain amount of leniency on the subject of insurable interest, and to back this up, I'm reminded that the law commissioners had a campaign to review and maybe revise the principle of insurable interest. I think this was from around about 2018, so it was a few years ago. And they even went so far as to issue a draft insurable interest bill. But they found themselves focusing mainly on life insurance. And the law commissioners came to the view that there's not much wrong with the way that insurable interest is operating now. And they didn't feel that general insurance needed to be included in a draft bill. In actual fact, the bill never went anywhere for reasons that I don't fully understand. I think the law commissioners probably felt that the best just leave things well alone. But that was in 2018. And the only comment I would make in relation to that is that when we see claims rejected, more and more of those decisions are taken by the insurer's lawyers rather than by insurance
Insurer.
practitioners. And
Yeah.
so I'm just a bit concerned in case lawyers might take a less flexible and less reasonable approach to issues of insurable interest. So if you take the case of the restaurant, where the actual owners of the restaurant were not actually mentioned on the policy, I imagine that most lawyers would say to the insurers, well, you don't have to pay this claim. And so maybe the reasonable, fairly laid back atmosphere that existed when the law commissioners considered this might actually tighten up a little bit. And I think that's just something we need to watch out for.
Yes, I remember that review, and I remember speaking to somebody of the Law Commission about it. But my impression at the time was that there's nothing wrong with the principles and practices of insurable interest in themselves, and that's why I don't think they needed to change it. I mean, it's a doctrine more than a law, and if you just think about it in the way that we've tried to discuss this morning, I think it works all right. The issue is if you don't think about it and get caught out. And of course, lawyers are paid to give advice to insurers to say, well, actually, we could argue there's no insurable interest, and we have to advise you that if there's no insurable interest, you may not have to pay this loss. Now, the insurer can say, well, thank you very much for that, but I am going to pay it. But sometimes they don't. And that's the issue, isn't it? And the insured, I don't think there will be anybody on the planet that would be able to write half a page of A4 on what insurable interest is in their own insurance. It's just not something that people consider. But it's tragic when it gets to some of the examples we've seen, and nobody thought about it, and nobody questioned it. And there we are. Stark situation is the law does say, well, you haven't got an insurable interest, and the contract can therefore be set aside.
So before we throw open for questions and answers, I think to summarise our view, where there's a difficulty to do with insurable interest, these 4 bullet points, that where there has been a genuine mistake, the premium has been paid, the insurer's position has not been prejudiced, and there's been no breach of policy terms, that we would normally expect the insurer to look for an opportunity to honour the contract rather than to look for a technical way out. That's what we would normally expect. That in my view, certainly is the fair and reasonable approach, which is really what we base our views on. What is fair and reasonable in the circumstances.
Yeah.
So with that, let's see if we've got any questions. Have we lost our connection to the CII?
I think you might have gone.
No, I'm here. Thank you. Thanks for that. That was excellent.
I thought
yes, we've got quite a few questions actually. No, I'm still here listening. Okay, right. So yeah, there's a number of questions. We won't be able to get through all of them, I don't think, but I've already been going through them as they've been coming in and trying to sort of minimise the duplication. So, the first question that came in, actually, hopefully you can answer it. Is there an insurable interest for a gifted item given to a grandchild who's under 18?
God, that's a clever one. Well, that's a really difficult thing. I think in principle, and this is the difference between the law and, if you like, the integrity of insurance. The question I would ask him is, well, why shouldn't there be?
I would say, Roger, sorry, Roger, if it's a gift, there's probably no insurable interest on the part of the donor.
Exactly.
But there would be on the part of the child's parents, who have a legal responsibility for looking after the child and the child's property. So I would say that the insurable interest rests with the child's parent or carer or whatever the circumstances are. But I don't think the donor would have an insurable interest.
No, if you were to apply the test of did the family, i.e. the parents and or the child, lose something as a result of the gift being destroyed? The answer is yes, they would, wouldn't they?
Yes. Yeah.
Yes.
So,
Great.
and again, I'm doing this off the top of my head, and a lawyer may say, don't be ridiculous, but actually it would be the right thing to do to pay it, unless there's a jolly good reason not to. That's the difference between
Yes, but I wouldn't
insurance.
expect the insurers to pay it. Sorry, I wouldn't expect the insurers to pay it if the claim was submitted by the donor, because
No,
once you've
nor would
made
I.
a gift, you've lost control of the gift.
I would agree with that.
Yeah.
Yeah. But the parents.
Great.
Yeah,
Okay.
I think so.
Thank you very much. And this next question, is the basic problem of insurable interest one of terminology? For example, if we called it financial interest instead of insurable interest, would that help consumers, clients to understand better?
That's a good way of looking at it. Yes.
Yeah.
Yeah. Pecuniary is the word that the legal profession use, but financial interest is as good as, yes. If you are going to financially lose as a result of the loss of the thing or the damage to the thing or a liability accruing out of the thing, then and it would cost you money, then you've got an insurable interest in principle, yes.
I think that would be as good as anything. We haven't commented much. We haven't
Good.
commented much on liability insurances, but the same
No,
definition would be quite apt there, wouldn't it? Because you
yes, it's
run a financial risk of being sued if something goes wrong. So I think that would work quite well.
Yep.
Great. Thank you. Just wanted to point out to everyone at home, Michael's camera has frozen. We can hear him really, really well. But just so you are aware, Michael, you aren't just a statue. You are.
Well, we'll give a point
It's not
out.
a bad pose. No, it could be. Could be worse.
No, it's a good pose.
Beaver's
Yes.
camera, isn't it? Anyway.
Yeah, we'll blame Beaver's. Right. So the next question is quite a long one. This one, but it's so this comes from John. We've had a number of cases where the property owner has allowed their tenant to arrange the building's insurance. This is normally when the business is a shop, particularly a takeaway. We've always warned property owners against this and also advised them that the wording of the lease may need to be amended to allow the tenant to insure the property. Are we correct in this, or the fact the landlord has given the tenant verbal confirmation is sufficient? We've always advised the landlord property owners to get their name noted on the policy as an interested party.
Michael?
Well, I think it's a little bit of a slippery slope, that. I think if we were presented with a claim and the insured was the leaseholder, in this case, a takeaway shop or something, we could argue that they've got an insurable interest, but do they have an insurable interest to the extent of the full value of the property? I think it creates far too many problems, and I would be against that. I think the questioner's automatic assumption that it really ought to be insured either by the freeholder or the owner would be by far the better arrangement.
The thing you'd have to think about is whether if the building is damaged and it's a leased property, the question is, what does the tenant stand to lose by the damage to the building? Now, that comes down largely to what the lease requires. And that's why it's important to have regard to what the tenant's responsibility is. If, for example, there's a full repairing lease, there are occasions when the tenant may say, well, I've got to be responsible for replacing that, although I didn't cause the loss. And that's why there needs to be a little bit more joined up thinking between the legal aspect of this and the insurance aspect. Because I'm not going to give an answer as to whether what the broker or whoever's asked the question, whether it's right or wrong, because we don't know the facts. But what you've got to do is to find out what the facts are. What you can't do is to answer somebody's question on a question like that. You can't know if you're right because you don't know whether their question is right. It's very dangerous to say, oh, that'll be all right, you'll be insured. Unless you've got the documents in front of you, you really can't answer the question. Now, I know that when you're talking to a takeaway owner, the last thing he's going to do is going to be worried about documents. He's going to say, look, you're the broker, tell me what I need to do. So it's not a very helpful answer. But the truth is that you may or you may not have a responsibility. It depends on what the lease requirements are, what you've signed up to.
Okay. This is a question referring to the example 2. Why wasn't the liquidator held responsible as they cancelled the cover and not the broker?
Because they have an absolute right to do so. And actually, it's a very good question. I'm glad it's raised, because for many years I have tried in vain to influence a code of conduct with liquidators and insurances, because they regard them as just a bit of money. Usually insurance premiums recoveries are not that big in the scheme of things, but the first thing they do is cancel the insurances with no regard to the consequences. And I think it's fundamentally wrong. But they can do it, and you can't sue them for it. People have tried and failed.
I suppose, Roger, we ought to just add that sorry, I'm not defending the liquidator there, but I assumed that he had no reason to know that the ownership of the property was in a different name to the limited company that he was winding up. So if he didn't know about that,
you see, this is where you're getting into the weeds now. The answer is that you could argue that he did have reason to know, because he had all of the documents concerning the business and the property. He knew everything, but he can cancel the policy. If there had been something in there to put him on notice that there were other interested parties, then if he'd failed to notify them, you could probably have sued him. But there was nothing in the policy to alert him to do anything, and therefore he didn't. And I think it's a moot point, and it's one that you could really spend some valuable time in looking at what the unintended consequences of that are. But there's a lot of people that come a cropper through that.
Mm-hmm. There's just a comment here, not a question as such, but saying that we're really interested in maybe a follow-up webinar on liability examples, if that's something you would consider.
Yeah, we can do that.
Yes. Yeah.
Put that in the list. Yes, we could do that. Yeah.
Yeah. Okay. Okay. Just reading some of these questions a bit longer. Okay. Here we go. Similar to example 1, prior to the 2007-2008 financial crisis, our policyholder acquired substantial personal liabilities through personal guarantees given against personal loans that were invested in property development. At that time, he removed his financial interest in his home and transferred the title to his spouse and children. This has remained the case thereafter. As the policyholder deliberately removed his financial interest in the property, can he now argue that he has an insurable interest in the property?
Well, off the top of my head, probably not, because if he's done that through a legal means to escape it, I don't think he can have it both ways. But again, it's a matter of fact. The answer is it's a matter of fact, and we don't know the facts. But in principle, if he's created a device to escape responsibility and have nothing to do with the thing, I can't see how he can claim for it afterwards. But
But I suppose if I was advising the family, and assuming that they're all getting on with each other, there's probably no harm in the original policyholder, in this case the husband or the father, still being named on the policy. It's where the person who has the insurable interest isn't named on the policy that you've got a real problem. But it's probably, if I was advising the family, I would go the safety first route and just include anybody that appears to have an interest.
Yeah, I don't think there's any downside in doing that. If in doubt, put it in. In fact, I mean, I would say that the antidote to this problem really is to have an intelligent approach to including people who have a provable insurable interest at the time of the loss. It's different from proving that they're an insured, because that means something different. But I think, Mike, I would agree with you that there would be no harm in doing that. What I would also say, though, from experience, I think that a lawyer would say, well, you haven't got to pay it. It comes back to that point that, if the chap has escaped his liability for other reasons, I think the lawyer would say, well, he can't have it back. He can't have it both ways. Anyway, it's an academic question in this case, but I think that's the way it will be looked at by the two sides of the coin.
Okay. Another question here from Richard. If a commercial property is let to the owner's own company and following a fire the company shuts down, can we happily expect insurers to pay the claim check to the landlord personally if they were only noted as an interested party, not a joint policyholder?
No.
No.
No, I mean, technically, the point is that they weren't an insured. And if there is any interest in that party, then they need to make sure that they're an insured. Noting of interest is just, as I said earlier, just to tell the insurer that if a claim is being paid out, you've got to tell these people in case they have a contractual right to any monies. But that's not a contractual right to the policy, it's a contractual right to the insured. And as you know only too well, I mean, a company and a natural person are two entirely different entities. So you've got to, it's a very good example of probably what happens every day. These are things that need just to be more carefully thought about rather than just wafted over, oh, that'll be all right. Which is why we're doing this webinar, because I think it's little things like that that make all the difference.
Okay. There are more questions, and unfortunately, obviously, we are going to be running out of time in a moment, so we will have to wrap things up. But thank you, everyone, for joining. Thank you both for delivering today's webinar and for all the valuable information that you've shared and the questions that you've answered. This session will be available on demand, so you can watch it back, but also feel free to share it with anyone who you think would benefit from it, which is probably most people working in insurance. Your CPD certificate and copy of the slides are available to download from this portal. So the final thing really from me is just to say a huge thank you to everyone for joining, and thank you both as well. So please feel free if you want to say anything, Roger and Michael.
Just to add very quickly, we will be sending you a fact sheet on this subject.
Excellent.
And the other thing is that we're about next month to launch a Flaxmans library, which will incorporate a large number of fact sheets and articles and all kinds of things we've been doing over the last 20 years. We've spent quite a long time putting these together into something that you can use, because a number of people have said to us, we quite like to use your material for training purposes. And we thought, well, actually, it's there to be used. So we're going to make it available, and there'll be an announcement about it, I hope, in the next 2 or 3 weeks. So watch out for that. Okay?
No, excellent. Well, let us know about that, and we'll make sure we push that out through our channels as well then, Michael and Roger. Okay. Well, thank you, everyone. We've just gone past 12 o'clock now, so thank you all for joining us. Have a great rest of the day, and we'll see you all again soon.